Justice Ganguly, your view, do you believe that the collegium system has outlived its utility or is not effective as the law minister suggests, or is the government trying to browbeat the judges into appointing those whom only the government wants?
You see, the collegium system was introduced as early as in 1993, reiterated in the presidential reference of 9 judges in 1998, and when that was sought to be replaced by NJSC Act by making an amendment of the Constitution, 99th Amendment, that was outlawed again by the Constitution made to the Supreme Court in 2016. So there are 3 judgments of Supreme Court, and since 94 onwards, the judges are appointed both to the High Court and the Supreme Court on the basis of a collegium system. To question that now is to raise your voice against the law which has been declared. It is the law of the land under Article 141 of the Constitution. What the Supreme Court declares is the law of the land. And
but laws can change. But laws can be amended. But Justice Ganguly, laws can be amended.
No,
laws are not in permanence. Laws can be amended.
Yes, unless, listen, yes, unless it is amended, you have to follow it. You cannot disobey a law which is there, staring on your face, saying that it should be amended. That means, unless it is amended, you don't follow it. In the process, what are you doing? You are clogging the rule of law. Because people's right to go to court is being impeded because you are not appointing judges. This is a very, very unfortunate step taken by the government.
Can I bring in Sidharth Luthra
there?
You
don't like the law, but that doesn't mean you will not follow it.
Sidharth Luthra, do you believe?
Yes.
Do you believe, Sidharth Luthra, a solution can be found, or is this now heading for a direct face-off between the judiciary and the government, given the fact that the government has just returned, we are told, 20 more judicial appointments?
So the norm was that the government could return the names once, but if the Supreme Court sent them back, reiterated the names, the government would accept it, and that was the norm that used to be followed. What happened was, when the NJSC judgment came, there was a second round which was in relation to the memorandum of procedure, which at that stage the bench thought it best to leave it to the government. Now what is happening is that the government has been using the memorandum of procedure, which is the procedural aspects, to defer and to oppose certain names. Now, of course, the government is entitled, in the context of adverse intelligence reports or adverse or such adverse findings or unsuitability, to come back to the Supreme Court and say, look, we don't agree with this candidate and these are the reasons, and then the Supreme Court has to see the material and determine whether the government's justification is right or wrong. But what has happened over the last few years, I must say, is not only are judicial appointments being opposed, objected to, and not happening at the government's end, but there is also inordinate delay. We must remember, in a system of parliamentary democracy, there has to be a balance of power between the various institutions, and there has to be mutual respect for various institutions. The law minister may have a viewpoint that the collegium system needs replacement or needs change. That's his viewpoint. He's entitled as a constitutional authority to take that view. But till they bring in a new law, till they amend the law, that view of the law minister cannot be translated into a mass-scale opposition of appointment of judges. We have to understand the larger connotation. This is not about the law minister. This is also not just about the Supreme Court. This is about, Rajdeep, the common citizen's right to access of justice. Why are we working in a manner to try and impact the functioning of the judicial institution? Should it be a situation that by withholding appointments and delaying appointments, we ensure that citizens' access to justice is lost? That, with respect, I would say, is not good governance, is poor governance. And therefore, the intellectual debate between the executive
Are you
and the
saying, Sidharth,
judiciary, which is
Luthra has
also
become...
going on in court.
Are you saying it's become an ego battle? Has it somewhere
I'm
become
sorry,
an
I've
ego
lost you there,
battle now?
Rajdeep.
That the government of the
Rajdeep,
day
I've
is
lost
saying...
you. Can you repeat?
Do you get a sense that... do you get a sense that this is an ego battle? That the government, in a sense, is trying to sort of show its muscle, that this is no longer about the law per se. It's become increasingly any name that, most names that come from the Supreme Court, we won't accept it unless you change the earlier collegium rules.
I think it's not about that. I think the government is possibly, and one should get the sense of that, is possibly planning and building a kind of momentum for bringing in a revised version of the NJSC, which they're entitled to do. There's no dispute on that. The law will come, it will be tested. It is possible that the government may be able to bring out a better system of appointment of judges than exists today. But till that law comes into force, can we have this lack of respect for the judicial institution? Can we have a situation where we are constantly trying to undermine each other, an institution? After all, we must remember, we, and including the government, not just citizens, have to go to the courts often to get justice. So therefore, I think it is time for the government to reconsider its view and perhaps realize that they are dealing with not just the respect for each other, institutions, but also depriving the citizen. And that's the most crucial lesson which I think needs to be remembered.